This is WAAY 31 Law Call.
Welcome to WAAY 31 Law Call. I'm Sharon Dovia. Tonight we're taking your calls and questions on any legal topic. It's Ask Us Anything night, so call in your questions. The 31 Law Call number 256-536-0077. You can also email your questions. You can email any legal question on any legal topic any day of the week. You send it to lawcall@waaytv.com. And when we get to a show that's on point, we pull some out. We've got some of your questions coming up tonight. So we'll be answering all kinds of questions from car accidents, medical malpractice. I do family law, so divorce, child custody, things like that. Getting us started tonight, we've got William Meservey and Bobby Marsh, both from Timberlake and League, and they are personal injury attorneys. So that's things like car accidents, and we've got a video for you. We like to start off with a You Make the Law Call video. We pull something off of YouTube every week, and we show you how does a lawyer look at this. So we've got this red car. He makes that first lane change, but then maybe he didn't catch on that traffic up there was slowing down somewhat, and they'll play it again. You guys do these kind of cases when somebody's injured in something like this. So what are you looking at to analyze it?
There's rules of the road, and the first thing you would notice would be that he didn't have his blinker on when he initially merged in that right lane. And honestly, merging in and out at that kind of speed and that kind of traffic can warrant you a ticket for reckless driving. And citation for reckless driving in a collision might take that claim from negligence to wantonness or recklessness.
Which makes what kind of difference?
It makes a difference between just compensatory damages and compensatory and punitive damages.
Okay. And Bobby, talk us through what's the difference? What are we likely to see, compensatory, punitive?
And so the main difference really is, compensatory, it is there to compensate you for what you've been through. There's things like medical bills, property damage, things of that nature. Punitive damages, on the other hand, they're there to punish the conduct, so to sort of prevent it from happening again in the future.
Gotcha. So they're going to have to pay more if there's a traffic ticket or something like that.
And if that person is insured, right?
Yes.
A lot of times what you find is, that's not that person's first time traveling in such a manner down the roadway.
Okay.
And a lot of times they've lost a license or they don't have insurance. And that's one of the reasons it's so important to have full coverage and have your own uninsured, underinsured motorist coverage that will protect you in the event you get slammed into by someone who, isn't insured.
If that had been something like a medical emergency, does that change things? Or if it had been somebody who's texting and driving, that kind of stuff, does that make a difference?
Well, so to your first point, it does not make a difference if you are having a medical emergency like you sometimes see in these videos where they say, just trying to get this person to the hospital, I'm trying to get my dog to the vet.
You don't have the right to speed and endanger everybody else. Okay. What if they're having a stroke?
If you're suffering a medical emergency, it's a little bit different.
It is. And so, at that point, we're not so much looking at, what the driver did. It's more so what they're going through. The law may change depending on what's going on. Now, the texting and driving, that goes back to the punitive damages we talked about. That's reckless conduct. Okay. And that, again, obviously violates the rules of the road and certainly changes the case for you.
Gotcha.
And so a seizure or a heart attack or something like that, if the driver's going through that, can allow them to avoid liability in a claim.
Okay, totally.
Totally.
Okay.
So, if someone has a seizure going down the road, they would have a good argument that, they're not liable for that wreck. Okay. Now, if they have a history of seizures and they're supposed to be taking seizure medication or they're not supposed to be driving, those are different concerns that come into play. And generally speaking, someone who has a medical emergency going down the road, they're going to have some prior notice that, hey, I've suffered seizures my whole life or whatever it is.
Okay, how do you prove that? How do you, when you've got that case and you're trying to figure out, did they have a history? How do you prove that?
A major thing we'll look at is medical records. What did the doctor tell them about their condition? How long have they suffered from this? Previous accidents they've been involved in. You can find that with a driving record, things of that nature. So there are different ways you can prove the history of the condition.
Yeah, and to get those medical records, you're going to have to file a lawsuit so that you can get subpoena power to subpoena those medical records. So, for instance, if I'm representing somebody I can have them sign a HIPAA authorization that would allow me to obtain their medical records on their behalf, because you have an absolute right to your own medical records in the state of Alabama. But I can't get someone else's medical records, right? So in order to get the defendant's medical records, you're going to, have to issue a subpoena through the courthouse, and you're going to have to show some form of cause as to why. They're not going to let you just go out on a whim, right? So if they allege the defense that they suffered a seizure or a heart attack, and they're avoiding liability, then at that point, you can use that to go to the judge and say, hey, look, they're alleging this defense. I need the records to evaluate if it has merit or not.
They're probably going to make you pay for it, right? If you're the one seeking it?
They will.
Yeah, okay. We've got callers waiting. We've got Larry on the line with a question from Madison. Hi, Larry. Thanks for calling. What's your question tonight?
Yes, hello. How are you?
Good. How are you tonight?
Okay, I had an incident. I have 2 vehicles registered to me, and they were parked in my driveway, and my daughter backed into one of them and messed it up pretty good. And according to my insurance company, they will only pay for one because both of them are registered to them. Is there any truth to that?
Huh.
I've actually seen this exact case before, and we were able to get them to pay for both vehicles, but the individual did have to pay their deductible on both those vehicles. So if you have a $500 deductible, it'd be $1,000 because it'd be times 2. But claims against your own insurance company are contractual claims. You've signed a contract for them to provide you car insurance. You pay your monthly premium, and it's going to come down to the language of that specific policy. And while most Alabama policies are similar across different companies, they do vary. And so the answer is maybe. A lawyer would need to review the contract of insurance that you have with your specific carrier in order to say yay or nay.
Okay. We always invite you to send in email questions, and we got this email question from Alan. Alan had written in, I was on a drywall side job under no company or no workers' comp. The ceiling collapsed on me and my friend, had hospitalization and multiple areas of stitches. Who's responsible? The one who hired us or the property owner?
Well,
what do you do with that?
It's a little unclear from his question because he says who hired us, and then he says it was a side job. Typically a side job is going to denote an independent contractor.
Okay.
On top of that, for a company to have to provide workers' compensation insurance to an employee, you have to have more than 5 employees. So, in this particular situation, there's a good chance he's going to be left without an avenue of recovery. It's possible that the property owner has medical payments on their homeowner's insurance that would pay dollar for dollar medical bills up to a certain amount, irregardless of fault.
Okay.
But, there's likely not going to be a workers' compensation claim there because even if the company carried workers' comp, if he's just doing a side job and is a 1099 independent contractor, they're not going to provide him coverage. And so unless he has coverage of his own, there's a good chance he's going to be footing the bill on that one.
Okay. Good luck with it, Alan. Danny is on the line with a question from Decatur. Hi, Danny. Thanks for calling in. What's your question tonight?
Hi, I'm calling about a incident. My brother had a contract with a company, and he decided to go in another direction. So he called and asked them to transfer it over to me, and they agreed. Then they called him, and they called me, and had me come to another out of town to come in and sit down with them and set up the arrangement. Do the things I had witnessed all the way through. So I walked into the office, shook my hand, and said supervisor and everything, said had to approve it. So they put it on an estimate paper, and told me later on that he was going to put it on the computer, which the witness was there because he was doing something on the computer. But as I went through the thing, I went back to get my material and stuff. They reneged on it and said it never happened. So I've been trying to hire lawyers and stuff in another town, stuff like that, but I cannot because the judge said I had to tie myself to the case, and I can't find a lawyer to help me with this.
Was the contract ever memorialized in writing?
It was memorialized with my brother. It was memorialized with me through the estimate thing that later on he was going to put it in the computer with a witness. Then he told me I could come back and get it whenever. My friend told me I need to go in and get it right then. That's when he said, you can get it because you had to call me back a day or two before. So everything was finalized through him, I thought. But when I went back and get it, they said they never put it in the computer or anything.
Sure. So the question, it sounds to me, is was there ever a valid contract for the brother?
Right.
Yes, it was. It was.
Well, there was for your brother, but I mean for you, was there a valid contract?
Right, because for a contract you have to have that mutual agreement. So the real question is, did you sign anything? And it sounds like you did not in this case.
Yeah. So you can have a verbal agreement in the state of Alabama, but an estimate, I think, would give them an argument that this was not a formal agreement. This was, we were working towards an agreement and it was never finalized. But that would get very fact specific, and it would, come down to what the witness that you have says, what their understanding of what was vocalized in that meeting, and you'd have to try to piece together whether or not there's a verbal agreement. But it's going to be, a tough road to hoe without a written agreement in that situation, because a lot of times it becomes, mostly a he said, she said type situation, and those can be difficult to prove.
We're going to take a break. Be right back answering more of your questions. It's Ask Us Anything Night. Stay with us.
You're watching WAAY 31 Law Call, where lawyers come to help. Your rights, your calls, live. Hosted by family law attorney Sharon Dovia. With the personal injury attorneys of one of the Valley's most respected law firms, Timberlake and League. Featuring the knowledge of managing partner Michael Timberlake, with millions of dollars awarded to his clients. And the experience of attorney Will League, a strong courtroom fighter known for his commitment to winning. And the fellow partners of Timberlake and League Heath Brooks and William Meservey. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. I'm Sharon Dovia. Tonight it's Ask Us Anything Night, so call in your questions on any legal topic. We've got with us William Meservey and Bobby Marsh, both from Timberlake and League. We've got a lot of fans of this show. I was going through the airport in Huntsville last weekend, and Philip with TSA says he watches every week. Thank you, Philip.
Thank you,
Appreciate
Philip.
that.
Thank you,
we
Philip.
run into nice people all the time.
Absolutely.
We've got callers waiting. Judy's on the line with a question from Huntsville. Hi, Judy. Thanks for calling. What's your question tonight?
Okay, I want to know if there's a common law marriage in Tennessee.
Ooh, common law in Tennessee. So I don't practice in Tennessee. The state of Alabama got rid of common law marriage a couple of years ago. So if you fell into it, then you were grandfathered in, I guess, essentially, up until a couple of years ago. But they're no longer allowing them to be considered created in more recent times. Tennessee, I don't know the answer to that. Judy, what are you looking at? What's your situation?
Well, my son lives in Tennessee, but a lady's been living with him, and I just wondered for 11 years, and I just wondered if they have common law marriage in Tennessee.
Back when Alabama had common law marriage, or if you're looking at an older one, some of the things that they would be looking at would be, did everybody believe they were married? Did they hold themselves out as a married couple? Did they, did she perhaps take his last name? Did they do taxes together and say married? Things like that would help prove the case. But you can live together for any number of years, historically, the state of Alabama, and that's not necessarily a common law marriage. We want to talk a little bit about a new case that came out just this week that criminal defense attorneys are very excited about. Tell me about this case that just came out.
So it's really not new law, but it did reaffirm the Fourth Amendment right against searches and seizures that are unwarranted. And so it was a situation involving a man who was in a church parking lot, and he was a mechanic, and he was fixing a customer's car. I think he had responded to where the car broke down. Mm-hmm. And some police officers arrived on the scene. They asked him for ID. He said, hey, I'm working. I don't have time to fool with that right now. And they just went ahead and arrested him.
Yep.
And what the Fourth Amendment of the Constitution says is, and what the case law stemming from that historically has been, is that the police officer, in order to identify a person, is going to have reasonable articulable suspicion of a crime that they've committed or that they're about to commit in order to ask for an ID, unless you're driving a car.
Okay.
Right? Because driving a car is a privilege, and you agree when you get your driver's license that if you get pulled over, you will present that identification to an officer.
Okay.
So if you get pulled over in your car, you always have to present ID. But outside of that, the police officer is going to have to provide you with reasonable articulable suspicion, or at the very least to the courts, reasonable articulable suspicion of a crime that had been committed or was about to be committed in order to lawfully obtain ID. Now, a lot of times, police officers ask for ID and people just hand it over,
Yep.
right? And that's perfectly fine to do. But if a person does want to, stand on their constitutional rights,
Yep.
the police officer is going to have to come up with some, reasonable articulable suspicion. So this was a case that worked its way through the state courts, and it was found in favor originally of the police officers, and then it made its way up to the 11th Circuit, and it was overturned and reaffirmed in compliance with other case law.
Right.
And opening it up to possible lawsuits, right? For the person who was arrested to sue. Now, I don't know exactly how much damages you'd get there, but no immunity for the police officers for that one.
They did remove qualified immunity from the police officers.
We've got a caller waiting. We've got Mike on the line with a question from Huntsville. Hi, Mike. Thanks for calling in. What's your question tonight?
Hi, thanks for taking my call.
Sure.
I actually have a friend that I've loaned some money to, and they give me the deed to their home for collateral for the loan, and unfortunately they've made no attempt to pay me back, and I just wondered if I could file a lien against the home or just what I could do.
Yeah, so, probably the easiest thing would be
Go ahead and file for a default judgment, right?
Yeah,
Go in there.
you could certainly file in small claims court or in district court or in circuit court, and that would just all depend on how much money you lent your friend. But you could go ahead and just file a claim with the courthouse, and most of these type cases do happen in small claims court. So, the past couple of years, Alabama revamped those thresholds, and they increased them. So small claims court, I believe, now goes up to $6,000. District court goes up to $20,000, and circuit court can hear any of those, but can also hear cases north of $20,000. So small claims court, district court, you don't have such strict, stringent evidentiary requirements. So it's a little easier to navigate a case on your own through the small claims court process, and it's designed that way. And then certainly if your friend didn't respond to the answer or respond to the complaint with an answer, then as Bobby suggested, you could file for a default judgment. And once you either have the judgment from trying the case or the judgment from the default, then you could move to enforce it. And you could then register that judgment with the probate court in the form of a lien.
We've got a caller from Huntsville. Now, you're going to have to help me with the name again. Is it Shameker?
Yes.
Hi there. Thank you for calling in. What's your question tonight? Welcome.
Yeah, my question is very simple. With all this technology that's going on, when I'm talking to a possible contractor and then we have a conversation, and that conversation is recorded. Of course, both of us agree to that we will record the conversation. Mm-hmm. Now, is that contract, would that be a contract as good as the one that somebody would have to sign for the same thing for the job to be done?
It could be. A lot of times you see where recordings modify an existing contract.
Right, and it sounds like that. It could be negotiations, some bargaining talk, if you will, maybe an offer. But until you accept it, and until it becomes an enforceable contract, I would imagine it's difficult to enforce that agreement.
Yeah, you know, so it's always best to memorialize your agreement in writing. But if you just, you know, recited what the contract was and it's recorded with audio, and the person verbalizes that they agree to it, then, you know, you've got potentially there a contract. Now, you still have some things to prove if it were to make it to a court of law. You'd have to prove that is that person talking on the video. Now, that's easier if you've got video as well. So best practices is, you know, sort of the term that comes to mind here. Your best practice is still going to be to memorialize that in writing, sign it with a notary present, and that's just going to make your life a lot easier should anything go awry. But certainly for, you know, renegotiations or modifying, granting extensions, all those things that you might do in a construction or developer type contract, you know, the recording should suffice.
We've got Connie on the line with a question from Tennessee. Hi, Connie. Thanks for calling. What's your question tonight?
Yes, my son had bought a truck from a dealer, and the same day he bought it, he pulled up to a gas station, and it was on fire.
Oh, on
That's
fire.
not good.
It's not good.
He won't give him his money back. He won't give him the truck. He wants like $75 for a gas tank, $150 for a fuel pump, and we had found one fuel pump gas tank now for $65.
So is this a used car or used truck?
Yeah, but it come off a dealership lot.
Okay.
Potential lemon law claim there. You know, under Alabama law, if you buy a defective vehicle from a dealership, and there are different, you know, exclusions and things like that, so it's relatively fact specific. But depending on, you know, the mileage of the vehicle and the year, and you know how long and how many previous owners it had, he may have a claim against the dealership under what's known as the lemon law. And it's a way where if a dealership sells you a defective vehicle in the state of Alabama, you potentially have a right of action against the dealership for the price of that vehicle.
Yeah, the other thing you're going to want to do in that situation is you're going to want to review what warranties and guarantees were made in the paperwork, you know, because generally speaking, they're going to provide some guarantee or warranty there.
Yeah.
But, you know, and people have to remember this, with used vehicles, the old adage, buyer beware. I mean, in Alabama, you know, by and large, it's buyer beware. So, you know, but here, if specific guarantees or warranties were made at the time of the sale, then there would potentially be recourse there as well.
We're going to take a break. Be right back answering more of your questions. It's Ask Us Anything night. Stay with us. If you didn't get your questions answered tonight, here's how to get in touch with William Meservey and Bobby Marsh. They are with Timberlake and League in Huntsville, 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way.
And Sharon Doviet is a family law attorney. She does divorces, guardians, all things of that nature. She practices here in Huntsville and North Alabama. Her telephone is 256-539-7337, SharonFamilyLaw.com.
And thank you guys for all of your calls and questions. We'll see you next week.
Have a great night.